From supplementary list, item number 1.
Wait, Your Lordship. This is writ appeal is from the judgment of the London Single Judge, my lord, dated 6/3/24. No matter the issue before the London Single Judge.
My lord, may I pray if the matter can be taken up in the end of the board, my lord, because the council handling the matter is a bit stuck and a bit late, my lord, so I could not reach it.
Take a chance. On 22nd? 22nd.
Matter will be taken up on 22nd. May I, anyway, Your Lordship.
Please.
From the daily
Request
list,
for the respondent. So respond. What's the matter on 22nd April?
from the daily list, item number 2.
One agenda. Inform them. Yes.
Item number 2, query.
Your Lordship. Your Lordship, this is a matter pertaining to 302.
Yes, sir. This is
Conviction against conviction, Your Lordship, that the wife has been convicted for lying. Based entirely on the confidential statement, Your Lordship.
based on the confession sheet.
Only confidential statement.
So you take it up after. Paper book is ready.
Lordship, yes.
Everything ready.
Everything is ready.
Yes. Reading is complete. Paper book has already been filed. Post the matter for hearing. Anyone during the week commencing 22nd. Ascertain the date and give them the date.
Actually,
Item number 3.
You must come and argue. Only then we'll think about the reduction. Yes.
May I please, Your Lordship?
Lordship, I'm appearing for the appellant in this matter.
Yes, madam.
Lordship, we have filed the affidavit of service upon the private respondents number 4 and 5 in item number 4. And the service is complete.
Service complete.
Yes,
Yes.
my lord. Service is complete.
Who is appearing?
My lord, today it seems nobody has entered appearance. In fact, my lord, during the writ before the single judge also, none had appeared for the two.
Oh, when the matter is taken up for hearing, the counsel appearing for the appellant submitted that the service on respondent 4 and 5 is complete. And affidavit of service have already been filed. So it further stated that none appeared for respondent 4 and 5 before the single judge also. In order to give an opportunity to the respondents, as none appears, propose the matter. Immediate. Last week, after 22nd.
Lordship.
Item number 7.
Ascertain that. Spread it in such a way. Yes,
Wait, please, Your Lordship. This appeal is directed against the single judge order dated 23/2/2024, my lord.
sir.
This appeal is directed against the single judge order, my lord, dated 23/2/24, my lord. The grievance of the petitioner before the learned single judge, my lord, was that the pension has not been disbursed till date,
Pension?
which they are entitled to, the pension. My lord, the petitioners, the appellants herein are all, my lord, the former member of district council, my lord. And as per,
What is the order dated 6/2/2000?
my lord, that
24.
you will find at page 69.
That is right. Page number 69.
Yes,
In para number 3,
yes, sir.
after removing petitioner 1 from the array of parties, with regard to remaining petitioners, the case will appear.
My lord, insofar as the party which was struck off, my lord, because she was both the NDC and MLA. So as per the rule, my lord, they are entitled, I mean, a person who is holding a twin post is entitled only for one
Correct.
pension, my lord. So she opted for MLA pension rather than MDC pension, my lord.
Yes.
Since she was a petitioner hearing, my lord, she on her own decided to strike
But
off.
with regard to others, he says the order
With
dated.
regard to others, my lord, they are all MDCs.
Where is the order dated 6/2/2024, sir?
It is in the other item, my lord, which item number 8. Item 8.
Item number?
8. The main order, you lordship will find it item number 8.
This is item 7.
Yes.
Page number, sir?
Page number 99, my lord.
9.
99.
See, you have got a favorable order. They said they have, yes.
The only consideration, my lord, with which we are before your lordship is, my lord, here the prayer before the learned single judge was, my lord,
To grant the benefit.
not only grant the benefit, but also to disburse or clear the, my lord, outstanding, which has been pending for quite a long time, my lord. They have not been paid even a single penny from the date they ceased to become an MDCs, my lord.
But they have not received any
They have
fine,
not released anything,
even today.
even today, my lord. Only,
But see, if you
only
look at page 100,
my lord.
it says, Your Honor, voice of objection, that you have raised an objection, ensure that the respondent adhere to the commitment before the court. The court presently is of the view that the payments have commenced. The litigation can be closed at this stage with liberty to the petitioner to.
It was merely a paltry sum of rupees 1,000, 10,000, my lord. Whereas, my lord,
How can we calculate and say that this is the amount to be
that
paid
is
to
for
you?
them to decide, my lord.
Huh?
But that is for the respondent to calculate and, my lord, accordingly disburse. Here, my lord, the prayer before the learned single judge was to even direct the respondent to even clear off the back, the outstanding. The areas of pension as on date, my lord. That was not considered by the learned single judge. My lord.
Where is your
Because we were
pleading?
before-
Where is your pleading?
My lord, I don't see the,
Show that you are entitled to X amount, but they are paying you X minus amount. See, you cannot make this court as an execution court.
I understand, my lord.
It is not there.
No, it is not there. my lord. The
Then
only
how can we
difficulty-
do that?
My lord,
See, we will close this appeal, giving you liberty to work out the remedy in accordance with law. Even you can then file a contempt before the learned single judge.
My lord,
If the order has not been implemented,
correct, my lord. Your lordship is right. The only, my lord, here, the only grievance with which we are before your lordship is, my lord, there was no consideration of the arrear,
consideration of
arrear of salaries, arrear pension, my lord. There was no consideration whatsoever in that regard. Because before the learned single judge, my lord, we were also with a prayer that the respondent be directed to, my lord, release my arrear pension, which has been pending for a long. That was not considered. My lord, only on a mere statement by the respondent, my lord, that it has been, payment
it
has,
amounts to clear contempt. When they have considered, it amounts to contempt. You are going to work out your remedy before the single judge by filing a contempt.
my lord,
Don't file an affidavit that we have given an opinion.
my lord, we were only praying, my lord, if we be allowed to give a compilation of the pending areas that is due to us, so that, my lord, it will be easier for lordship also to adjudicate on this matter.
Huh?
My lord, we were praying, my lord, if some time may be given to us to find a compilation of, or maybe the index of what amount is due to us,
So when
both
this-
in
when
respect of.
this- When you approach the district council, approach the district council.
We have done that.
See, there
Every time,
are two options open to you, sir. Now there is a statement made by the
council.
council saying that they commenced the payment. Commence means not commence, including the early arrears. That is how the interpretation has got to be given.
That has
Because
not
you-
been given, my lord.
Huh?
That interpretation has not been given, my
That
lord.
is right. You can approach the learned single judge by filing a contempt. And if you want to work out your remedy before the district council.
My lord, if that be cleared, my lord, my only prayer, my lord, if that can be observed, that, my lord, the district council or the respondent, my lord, is also directed to clear off at least the pending,
No,
the
we will
area
not-
of
if
pension.
any, only we can say. How can we say that this amount, X amount
No, no,
is due to
if
you?
any, my lord, if any.
If any, we will say that.
Areas of pension, we are more concerned with the area of pension, or the prospective pension, my lord, that we can take care of later, at a later stage. But what we are, as of now, we are entitled also to the area of pension, my lord, that has not been cleared till late.
See, one thing, if we use the word if any, that means we are clarifying the order of the learned single judge. Then you cannot even file a contempt. Because on the question of doctrine of merger, the order of the learned single judge
Merged with-
get merged with this bench, or the division bench order.
Correct, my lord.
Then but then you cannot maintain it here also.
My lord, if some kind of an observation with regard to the pending arrear.
We'll give an order. Come. The present appeal has been filed. This was of both the appeals. The present appeal has been filed. Challenging the order dated so and so. The main grievance of the appellant or the petition before the learned single judge was that outstanding amounts to the retired ex-MDCs have not been paid. Even though statement was made by the counsel appearing with the respondent, objection was made by the counsel appearing for the appellant petitioner that only paltry sum has been paid and that the actual amount due has not been given. The respondent has stated before the learned single judge that they have commenced the payment. The plea before the learned single judge that the matter may be kept pending to ascertain about the commitment made by the learned counsel appearing for the respondent before the single judge, which was not taken note of, and that the learned single judge has disposed of the writ petition with liberty to the petitioner to initiate fresh proceedings in the event the commitment is not honored. So stop. When this court posed a question to the counsel appearing with the appellant as to the amount of pension payable to the retired ex-MDs have been pleaded, and averment has been made in the pleading before the learned single judge, the counsel fairly submitted that it has not been stated. He reiterated that so small sum has been paid as pension and substantial amount including arrears have been deprived. Stop. We cannot, the division bench cannot conduct a roving inquiry and compute the amount payable to the ex-MDs, retired ex-MDs, MDCs. Full stop. For the purpose of determination of the amount, if any, payable, the petitioners will have to, petitioner will have to approach the district council for redressal. Full stop. In case the commitment has not been honored, it is open to the petitioner to take appropriate steps in accordance with law and appellate remedy, appeal before this division bench, appeal before this court cannot be entertained. Hence, while disposing of, hence we are of the view that no relief in the writ appeal can be granted to the appellant. Hence, the same is closed by giving liberty to the writ petitioners, appellants, to approach the district council for the purpose of determination of amount, including the arrears, if any, payable, together with actual amount that may be payable to the retired ex-MDCs. In case any request is made to the district council, we expect the district council to decide the matter as expeditiously as possible.
Can there be a time-bound direction, my lord?
With a period of 6 months.
6 months, my lord.
Then 4 months.
No, 45 days if possible, my lord, because they are in seized of all the records. It won't take too long for them to
4 months.
Apology.
4 months from the date of register of the order. Both appeals are closed.
And the daily list, item number 1.
This is a matter for regularization, my lord.
Regularization.
Yes, my lord.
Why not we take up the matter on some other day?
My lord, certainly, my lord.
What's the matter? Commencing 20, after 22nd.
My lord.
Lords, yes.